Good morning. Thank you for joining us for the next webinar in our Charities Bitesize series. My name's Kate Harris. I'm a legal director in Birketts Contentious Trust and Probate team, and I'm joined today by my colleague Jenny Howe, who's an associate in our team. And today we're going to be speaking to you about the difficulties which a charity beneficiary may come up against if faced with an executor or administrator who's reluctant to provide information about an estate. So we're very lucky at Birketts to have an excellent charities team headed up by Liz Brownsell, who some of you may know. And we within the Contentious Trust and Probate team work very closely with them to advise our charity clients in relation to disputed legacies generally, but also in relation to any problems which may arise in the administration of an estate from which a charity stands to benefit. So we're going to start today by talking about the information generally which a charity beneficiary can, in an ideal world, expect to receive from a personal representative. We're then going to go on to discuss some of the options available to obtain that information if it's not provided. We're then going to look at some general considerations which a charity needs to be aware of in the context of litigation more broadly, as well as the information which should be made available to a charity beneficiary in the context of an estate, which is the subject of a claim. So there hopefully will be some time for questions at the end. So if you'd like to submit any questions that you do have into the chat box, which should be on your screen, we will do our very best to answer them. I should also say that a copy of our slides and the recording will be made available to you within kind of 2 to 3 days following the webinar. Have the next slide, please. So I think it won't come as any surprise to anyone on the webinar that there's no question that COVID-19 has had and is continuing to have an impact on charities. The latest research from Legacy Foresight suggests that legacy income is likely to remain broadly static at around 4 billion until 2025. At that point, it is predicted to return to growth and rise to around 4.4 billion by 2027. Interestingly, the bequest numbers for UK charities is expected to be around 11% higher over the next 5 years until 2027 than it was in the previous 5 years. So that's good news for charities, but with the continued strain which many of them are still feeling after the COVID-19 pandemic, with rising rents, lack of volunteers, all those sorts of things, it's more important than ever, we think, that charity trustees preserve legacies and that they understand and appreciate the rights that the charity has as a beneficiary and the duties and obligations that there are on a personal representative to observe and respect those rights. So next slide, please. So firstly, we're going to look at what information should a charity beneficiary expect to receive from a PR. So firstly, it's important to be aware that there's no rule, so no hard and fast rule as to when a PR should make contact with a charity beneficiary to inform them about their entitlement under a will. Some charities may find that they hear very soon after the death, while others will have to wait. If, for example, there's a delay in the administration process, which could be caused by a number of different things. It's also quite possible that a charity beneficiary may not be contacted at all by the personal representative and could instead find out about their entitlement through other means, such as a legacy notification company, or even directly from friends or family of the deceased if they're aware that the deceased had a very close connection with the charity and wanted to benefit them. So when a charity is contacted, it would be quite unusual for the PR or the solicitor's firm that they've instructed to volunteer a copy of the will under which the charity stands to benefit. However, I think as a matter of good practice, if the charity beneficiary does then request to see the will, you would expect it to be provided, not least because, as many of you may already be aware, a will becomes a publicly available document as soon as the grant of probate is issued. So I think it's fair to say that if you face resistance to when you ask for a copy of the will, that may be cause to have a little bit of concern, but not necessarily, but it might give rise to a kind of initial alarm bell. So if the charity is named as a residuary beneficiary, then it would be usual for the whole of the will to be provided. However, if the charity only receives a specific legacy, it would be normal for the charity to be sent an extract which shows only the terms on which the gift is made. Essentially, that's all that the charity has an interest in. I think it's fair to say that it's unlikely, I think very unlikely, that a PR will be in a position to tell a charity beneficiary exactly what their entitlement is likely to be at the outset of the administration. And this will certainly be the case if the charity is due to receive a share in or all of the residuary estate. So this is usually because the often lengthy process of ascertaining and valuing the assets and liabilities hasn't yet begun, or is complicated because of the nature of the estate or difficulties which the PR may have in locating or identifying assets. And if the charity is left a specific pecuniary legacy of, say, £10,000, for example, then the chances are that is what the charity will receive. But again, it will all depend on what the final estate looks like. And so a PR is going to be very reluctant to confirm that that's what the charity is going to receive at the outset. So if solicitors are instructed by the PR to assist with the administration, then the Solicitors Regulation Authority, or the SRA for short, does encourage residuary beneficiaries to be provided with not only a copy of the solicitor's terms and conditions, but also details of their charges. Do note, however, that this is best practice rather than a strict legal obligation on the PR or a professional obligation on the solicitors. But saying that, it's, I think, important for charities to be aware that the court has earlier this year made a decision in a case of Kellig versus TSP, which opens up a beneficiary's right to challenge costs which are raised by a solicitor's firm in connection with an administration, even if those costs have been approved by their clients, namely the personal representative. So that is an option available to charity trustees if they feel that unreasonable or high costs have been incurred in connection with the administration process. And that's obviously going to be more important if you are a residuary beneficiary of the estate. So in terms of how often you should expect to hear from a PR, so we certainly wouldn't say that that's going to happen on a regular basis immediately after the charity is notified of their interest in an estate. It's not unusual at all for there to be a fairly prolonged period of silence at the outset of an administration, as the PR will be busy locating assets, identifying any liabilities, in order to prepare the inheritance tax calculation and to submit the application for the grant of probate. It may very well be the case that a charity will not hear from the PR again until a grant has actually been issued and the PR is in a position to then make distributions. So as far as the nature of any updates and the extent of the information supplied is concerned, if a charity is only due to receive a fixed monetary sum under the will, then they should only expect to receive updates on the timing of the administration. And the same is going to apply to a charity who stands to receive a specific legacy of something else, such as a property. Although in that case, the charity can also expect to receive information about the likely value of the gift, so a valuation of the property, for example, as well as options about how the gift might be transferred to the charity, if appropriate. And that may be likely in the case of property for tax reasons. Now, a residuary beneficiary will receive the same updates, but will also be entitled to see a schedule of assets and liabilities, estate accounts once they've been finalised, details of any income received into the estate, and copies of valuations excuse me, of the estate assets. If a charity is a remainder beneficiary under a will trust that has an intervening life interest, then they will usually be entitled to see up-to-date trust accounts, during the life of the trust that relate to the property in which they have an interest. And that's so that they can be certain that the trustees are doing what they should be doing, and then there's an appropriate balance being carried out between capital appreciation and the income. Finally, there is the Law Society's Wills Inheritance Scheme accreditation, which doesn't apply to all firms, but I think is becoming increasingly popular, is a best quality mark for wills and administration advice. And that requires member firms to inform beneficiaries of their interest in an estate as soon as practicable. They're also required to give beneficiaries an estimate of the time frame for the administration to be completed, together with details of any time constraints that may apply. And finally, there's also a requirement to inform beneficiaries how often they will receive updates, which you can see are all going to be very advantageous tick boxes for a charity. So while all those things would ideally happen in every administration, the reality is that it is often impossible to give accurate time estimates or to predict what hurdles may need to be overcome during the course of an administration, especially at the outset. And so it's not going to be the case that every PR who falls short of these best practice requirements will automatically be in breach of their duties for failing to provide adequate information to a charity beneficiary. The key is going to be to consider the individual facts of each case and to think very carefully about why certain information is not forthcoming and whether, in fact, there is a reasonable justification for that happening. Finally, just a kind of practical point to mention is that if there are multiple charity beneficiaries sharing in a residuary estate, it's not going to be uncommon for a lead charity to be nominated to communicate with the personal representative and then to feed back the information they are provided with to the other charities. So quite clearly, this is a very sensible solution. It saves on time and therefore cost, which ultimately is going to increase the residuary estate and is going to be a benefit for each of the charities that is due to benefit. So I think if you are a charity and you know that you are named alongside various other charities, I think it's a good idea to get together at an early stage and to agree one charity that is going to be the lead point of contact. So taking all of those things into account, I think it's obvious that it's not always going to be straightforward to know when a charity might need to take formal action to obtain information about an estate and the administration process more generally. So while I've touched upon some of the practical points about the information which a charity might and should expect to receive, the very basic legal position is that a charity beneficiary's right will extend to having the estate duly administered in accordance with the will, and that's embodied in section 25 of the Administration of Estates Act 1925. So what a charity really needs to think about is how to enforce those rights if you are not being provided with the information that you need in order to essentially tell whether those rights are being abided by. So, and that's going to depend on the facts of each individual case. So you can have the next slide, please. So there are various, sorry, next slide. I skipped one, apologies for that. So there are various different options available to a charity beneficiary if they are not being provided with information, or if they don't feel that they're being provided with enough information. The first option is going to be to make an application for an account of the estate administration. And just by way of a kind of practical example of how this might work, this happened in the 2016 case of RNLI and others versus Headley and another, where there were a number of charity beneficiaries who brought a claim together against executors for accounting information. And they were successful, not only in obtaining the information they were after, but also in recovering costs from the executors. So I'm just going to whiz through the facts of that case just to give you, as I say, a kind of practical example of how this can work and the sort of circumstances in which it might be necessary. So in that case, John Headley and Kevin McColl, they were both solicitors at Headley's Law in Leicestershire. They were appointed as executors of the will of Evelyn Farmer, who died in 1996. The will created 2 life interests for adult beneficiaries, the testator's son and her daughter-in-law. And upon their deaths, the estate was to pass to 10 charities, including the RNLI, British Red Cross, Guide Dogs for the Blind Association, the RSPCA, and the Leonard Cheshire Disability. So some fairly large and well-known charities. The estate was actually incredibly small in relative terms, so it was worth no more than about £145,000. And the executors acted promptly. They obtained probate fairly quickly and completed the administration, at which point the trust came into being. Now, some of the charities chased the executors for information over the next few years, asking for particulars of the property making up the trust, details of the income, expenditure, and any distributions that had been made. A set of provisional accounts was eventually provided in 2007, so 10 years later, but that was the only communication that was received. So in 2014, having finally run out of patience and in the face of continued silence from the executors, 5 of the charities instructed solicitors to act for them. So while those solicitors did manage to speak to the executors firm on the phone, they were unsuccessful in obtaining any further information. And finally, they left with no other choice. They issued a claim against the executors in February 2016 under Part 64 of the Civil Procedure Rules, seeking proper particulars and accounts. It was actually only at this point that they were told that John Headley, one of the executors, had died a year earlier. So the claim came before the judge at an initial hearing, and the court held that the obligation to provide information devolved in the surviving co-trustee, Mr. Cole, which meant that Mr. Headley's estate didn't need to be a party, which simplified matters. Although actually in the event, Mr. Cole, despite being the only named defendant and the single continuing trustee, excuse me, didn't appear at court, didn't present any defence to the claim. And so the judge, Master Matthews, was left to make his decision based solely on the evidence provided by the charity claimants. So in doing so, he gave very careful consideration to what information the charities were actually entitled to, and paid particular attention to whether the charities were entitled to information about the income of the trust when they themselves were not beneficiaries of that income. The charities sought to rely on the general rule which was established in the 1998 case of Armitage and Nurse, which states that beneficiaries should be entitled to see the trust accounts regardless of whether they have an interest in possession in relation to the trust property. So it follows from this that trustees must be ready to account to beneficiaries for what they have done with the trust property, whether that be in the form of financial statements or in a less formal manner, but providing the same information. What's not clear, however, from the general principle is whether different classes of beneficiary are entitled to different types of accounting. So Master Matthews, considered this point, and he held in this case that the level of disclosure by the executor trustee will depend on what is needed in the circumstances for the beneficiaries to appreciate, verify, and if need be, vindicate their own rights against the trustees in respect of the administration of the trust. So it's probably not surprising that the judge also made it clear that this would vary depending on the facts of each individual case. So Master Matthews went on to say that because the charity's interest in this case was not yet in possession because the daughter-in-law was still alive, he could not see any basis for the charities having an accounting as to the income accrued or paid to the income beneficiaries. He justified that by saying that if the executor trustee does not pay the income to the life tenants, it's only the life tenants and not the charities who can complain about it. So his view was that the charities didn't need the information about the income that had been paid out in order to protect their own interests. However, that said, the judge had absolutely no difficulty in finding that the executor trustees were in breach of duty by failing to provide the charities with information in relation to that part of the trust in which they had an interest. And so the judge ordered an account of capital, list of investments, and a breakdown of the trustees' fees and expenditure insofar as those had been deducted from the trust capital. So the charities did obtain the majority of the information they'd been asking for. So when it came to costs, the judge found that the neglect of the executor trustees had been so bad that he described it as gross, and their refusal to provide information over such a long period of time was unreasonable. So there's no question in the judge's mind that the surviving executor trustee should be liable for the claimant's costs, albeit that was subject to the usual assessment process. But he also went one step further by ordering that the trustee was not able to claim his own costs back from the trust. So as many of you will be aware, that's a departure from the usual rule under CPR 46.3, which will usually allow an executor or trustee to recover costs reasonably and properly incurred from the estate or the trust on an indemnity basis. However, in this case, Master Matthews was not prepared to allow the executor trustee to take advantage of that provision because, in essence, he found that none of his costs had been incurred reasonably or properly. So can I have the next slide, please? So just briefly, so the key points to take from this case for charity beneficiaries are that if you're making a claim for an account, if it's going to be successful, you need to be very careful about the way it is drafted, and it should be limited in scope to information in respect of which the charity beneficiary has a current interest. So that's going to be really key, both in being successful in the application itself, but also protecting the charity beneficiary's position on costs. And just another point to mention, be aware of, is that although the charity beneficiaries were successful in this case, they still suffered some irrecoverable costs, around 25% through the assessment process. And that's, again, going to be a key consideration for charities when deciding whether to embark upon litigation more generally. Just very, very quickly, because I'm conscious of time, if an application for an account doesn't work or isn't appropriate for any reason, there is always the option to pursue the removal of an executor or an administrator on the grounds that they are not acting in accordance with their duties. And that's likely to be successful if it can be shown that it's in the best interest of the estate and the beneficiaries as a whole for that PR to be removed. But costs of such a claim are very high, they're not necessarily straightforward, and they can be incredibly contentious. So we would always recommend trying to find an alternative solution and taking advice before going down that route. So it leads us on quite nicely to a quick kind of reminder about charities and litigation more generally, and I'm going to hand over to Jenny, who's going to speak to you a bit about the key charity law duties which trustees should be alive to when they're thinking about pursuing a litigation. Thank you.
Thank you, Kate. Okay, so just thinking about those charity law duties, the first one, perhaps obviously, is the overriding duty on trustees to act in the best interest of the charity, both in the short and the long term, and to further its charitable purposes. And in order to do that, the trustees need to consider the core values of the charity, its general mission statement. And in carrying out that duty, the trustees will need to consider the importance of safeguarding the charity's reputation, but also protecting the interests of the beneficiaries of the charity as a whole. Secondly, the trustees have a duty to collect and preserve charity assets, and that extends to recovering charity assets. And in terms of what we're talking about today, a charity asset will include a legacy which has been pledged to charity under a will, even if it's not yet been paid out. Thirdly, there's the duty you'll be familiar with on trustees to act with reasonable care and skill, and that means that trustees must ensure that they seek and consider expert advice so that they can be sure that they have sufficient information to properly understand the charity's position, how best to approach any litigation or a dispute short of litigation. And the fourth point is that trustees will also have a duty of prudence that requires them to assess the risk to the charity of engaging in any form of dispute or litigation. And that extends to ensuring that the charity's resources are properly managed and acting reasonably so as not to expose the charity and its beneficiaries to any undue risk. And as I touched on above, that will include considering the risk to the overall reputation of the charity and engaging in litigation. It's in the public domain. So when I just wanted to talk a little bit about when a charity is involved in estates where there are disputes. So the risk needs to be actively managed in those situations where there's a dispute affecting an estate and therefore the potential for litigation. So the kind of information that you'd be entitled to and we expect to receive where a charity benefits from an estate where there is such a dispute. And by third party, I mean another party who's bringing a challenge against the terms of the will in some form or other, which could impact upon the charity legacy in the will. And careful consideration needs to be given to what role, if any, the charity will play in that dispute and how that plays out. There are many ways in which estates can become the site of disputes, and I'm going to outline just a couple of the scenarios which tend to crop up most often in our practice, and address the categories and the nature of the information that you would wish to see in those sorts of cases, and would be entitled to, certainly as a potential defendant to a claim being pursued by others against the estate. That's not to say, of course, that a charity can't initiate a claim. For example, if a charity had benefited under a will and that will have been changed and the new will left the charity out, if there were concerns about whether the new will was valid, perhaps because questions about whether the testator had the requisite capacity to make the new will, or there's possibly evidence of undue influence being brought to bear on the testator to change the terms of the will, the charity would likely have a duty to consider then and take some initial advice, at least, to identify the likely costs and the prospects of challenging the new will, so that they could really weigh that in the balance with the possible loss or reduction of whatever they would have received under the old will. On the other hand, if there's a dispute between other parties which doesn't threaten to disturb the charitable bequest, and maybe that's because the disputing parties want to honour the testator's wish to leave money to the charity, but there's a dispute between themselves over how the rest of the estate is distributed, the likelihood is that the charity wouldn't need a great deal of information about their dispute at that stage. You could reasonably expect to be provided with updates intervals from the disputing parties, and as to whether and if so when their dispute might be resolved, and that would assist in enabling the charity to consider its strategy, whether they became more active in efforts to settle, and what their next steps would be if settlement looks unlikely. Now, moving on to talk about a type of claim which crops up fairly regularly, 1975 Act claims. The case of Blue Cross and ILOT is very well known amongst practitioners because of the involvement of charity beneficiaries and their status as charitable defendants. I'm sure it's very well known amongst charity legacy professionals too. It's a landmark case on financial provision claims against estates, in particular brought by adult children of the deceased. And that legislation, it's the Inheritance Provision for Family Independence Act 1975, enables people in certain categories, such as children, surviving spouses, to bring a claim against an estate if they consider that the will didn't make reasonable financial provision for them. So again, just to whiz through the facts of ILOT, because I'm sure it's very well known. The testatrix made a will which left her entire estate of around £486,000 to a number of animal charities. She left out her estranged adult daughter entirely, quite deliberately. She made that decision a long time ago in 1986. She'd written to her daughter and told her that she wouldn't benefit. She wanted the solicitors to defend any claim her daughter might bring. So testatrix died in 2004. At that time, her daughter, Mrs. Illett, was living in housing association accommodation. She was almost entirely dependent on state benefits, and she brought a claim against her mother's estate. Now, at first, she was awarded £50,000 out of that estate. She appealed that because she thought she should be entitled to more. The Charities also appealed on the basis that they didn't think that she'd met the threshold for getting anything at all. That appeal was dismissed, and then followed some further years of litigation over the correct assessment of the award that Mrs. Illett should receive in the context of a whole host of factors which are at play in those sorts of claims. The Court of Appeal initially increased the award to £143,000, but ultimately it was reduced back down on appeal to the Supreme Court, back down to £50,000, which is where it rested. So in the course of that long-running litigation, the status of charitable defendants was considered, and the Charities in that case did take an active part in opposing the claim, but they didn't advance any particular financial need or reliance on the gifts of the testator beyond a general obvious statement that the Charities depend quite significantly on bequests and wills in order to fund their work and to further their objectives. Now, as a party to a provision claim, initially as defendants, the Charities would have been entitled to have a copy of the claimant's letter of claim, setting out the legal basis of their claim, the factual matters that they were going to rely on, and advancing the claim that the will didn't make reasonable financial provision. And as part of that disclosure, the Charities would have also been provided with detailed evidence as to the claimant's financial needs and resources now and in the future, information about health needs, conditions. In short, they'd be entitled to receive everything which amounts to the claimant's claim. And in addition, a charity should expect to receive a copy of the will and information as to the size and the nature of the net estate. And as Kate was saying earlier, you may well have received that earlier on being notified of your interest. But if you hadn't been, you should certainly expect to receive it at this stage. That information should be provided even-handedly by the executor of the estate to all parties to the dispute, with the aim really of resolving matters as quickly and cost effectively as possible. If the executor were not doing that, then often a reminder as to their duties to remain neutral, to assist the parties will be enough. If they're persistently departing from their position of neutrality and breaching their duties, for example, they're providing information to one party but not to the other, and if less formal requests for that information fail to elicit the details needed, then an application for their removal and replacement might be considered as a last resort. And another claim which might affect a charity beneficiary is a probate claim, where there's a challenge to the validity of a will. So, for example, a disappointed beneficiary might argue that the testator didn't have the requisite capacity to make the will in question, and if proved, that would mean that the will was not valid. In that case, they'd usually support their claim with evidence such as medical records, expert witness reports from medical professionals, witness statements of fact from people who knew the testator well. And again, as a charity beneficiary, as a defendant, you should expect to receive copies of all of that evidence in order that the charity can weigh up the risks and the prospects to enable them to take advice and consider strategy, potentially settlement through some form of alternative dispute resolution. And in another point to make, a practical point, in validity cases where the will has been professionally prepared, an early step taken by the challenging party usually is to request a copy of the will file of the person who prepared the will, and they will be seeking to establish the circumstances in which the instructions to prepare the will were given, and also around the signing and witnessing of the will. Now, where gifts have been left to a charity or charities, the will file might shed some light on any particular affection for or commitment to the charity that the testator had. It might be evidence of lifetime gifting or bequests made to the same charity or charities in previous wills. But those looking to challenge on grounds of validity might point to the absence of any such connection in those files, and if they're attempting to build a picture of a marked departure from previous wills, or even that a decision to radically change a will and leave a large bequest to charity might indicate questions irrationality, lack of capacity, if there's nothing like that in their previous will-making pattern. But obviously that sort of argument would be just one of a whole host of things in a broader approach to establishing capacity or lack of capacity. And in any case, a charity beneficiary should expect to be provided with all of that evidence, copies of relevant will files, so that they can consider their position and take advice. So in summary then, charity beneficiaries are in a similar position to any other beneficiary, a lay beneficiary, in terms of the information they're entitled to, but charity trustees will have additional considerations when they're faced with an uncooperative or an uncommunicative executor, because they will first and foremost need to ensure that they're complying with their key duties. It's not difficult to see how the decision whether or not to embark upon litigation can be a very difficult one for a charity. So obtaining professional advice at an early stage is often key, and that's not only to ensure that the charity is able to demonstrate that it took all proper and reasonable steps before pursuing a claim or a particular course of action, if that's short of a claim, but also because putting requests for information on a more formal footing may be enough to elicit a response, short of having to become engaged in litigation. But of course, no guarantee of that. Okay, so that brings us to the end of what we wanted to say. I'm just going to have a quick look and see whether any questions have come in. I know I'm conscious of time, so if there aren't any, our details are on the next slide, contact details. If anything occurs to anybody later on, please do email questions in, and we'll do our very best to answer them by responding to the emails. And I think, are there any questions? I can't see any.
No, I can't see any. We've obviously done such a good job that no one has any questions. But as Jenny says, if there are any that you think of afterwards, our contact details are on the screen now, but will also be on the slides that you will have. So please do feel free to drop either as an email, and we'll come back to you. And I think all that is left for us to say is that keep an eye out for our next Charities bite-sized webinar. Details of that will be published on the usual channels on LinkedIn and by email, and hopefully you can join us for that one. But thank you very much for your time, and enjoy the rest of your day.
Thank you.